Hey everybody, this is Mr. Maupin coming at you with another APGov video. This one's focusing in on topic 3.9, taking a look at due process and the right to privacy. So when we talk about due process, there are two components to due process. Now previously we talked about procedural due process, which is basically the steps that the government must follow if it wishes to legally deprive you of life, liberty, or property. But there's another component to due process that exists, which is protected, the 5th and 14th Amendments, just like procedural due process, and that is something called substantive due process. And what this is talking about is the idea that, when the government is attempting to limit rights, it must apply a sense of fairness, a spirit of fairness, when doing that. In other words, the government, because of substantive due process, cannot just deny someone a basic right for no good reason. That if it is a fundamental right in particular, there's an assumption, as a part of substantive due process, there's an assumption that the government cannot take that right away unless there's just some massive, compelling, just unbelievably significant, state interest in doing so. And the question when it comes to substantive due process is, what are these fundamental rights? The idea being is that if it is a fundamental right, and we're going to make the assumption that the government can't take that right away under substantive due process, then the question becomes, what are these rights? Now, some of these rights are clearly enumerated, such as the right to, freedom of speech, freedom of religion. Some of these things are enumerated in the Constitution, particularly the Bill of Rights. But what about things that aren't enumerated? For example, the right to privacy. If you look in the Constitution, you will not find that word in there at all, privacy. You will not see the phrase right to privacy in there. So the question then becomes, is something that would be an implied right, would that be something that would be considered a fundamental right that cannot be arbitrarily denied by the government? Well, the first case that deals with this question is the case of Griswold versus Connecticut. Now, the Griswold case was focusing in on a state law in Connecticut that basically banned access to birth control. Now, in this court case, this is the first time that the court asserted that there is an implied right to privacy that we all enjoy. Even though it's not enumerated in the Constitution, you won't find the Bill of Rights anywhere, there is, according to the court, an implied right to privacy. Now, where does that come from? Well, first off, it comes from the 9th Amendment, which is the allowance for implied rights. Remember, it tells us that, the rights that are enumerated are not to be assumed to be the only rights that we might enjoy, but to make it a specific implied right. In this case, the right to privacy is attached to the 4th Amendment, protection from unreasonable searches and seizures. So when we think of the 4th Amendment talking about unreasonable searches, we tend to think of things like our, property, like our house, our car, our purse, whatever. But what the privacy is talking about is that this protection from unreasonable searches also extends into certain decisions that we make about our bodies and certain decisions that we make for ourselves within our own home. So the idea being that, if a couple wanted to use birth control while engaging in sex, that's seen as a right that people fundamentally get to enjoy from being intruded upon by the government arbitrarily. That, in other words, that right to protect from reasonable searches is not just about tangible things like your car or your house, but it also applies to decisions that you make about your own body behind closed doors. So this is where we get the right to privacy existing in the first place, as this idea of a fundamental right. The next question then becomes, okay, what types of things would be considered a right to privacy protection? If right to privacy is a fundamental right, then, what about other things that might fit into that category, such as abortion? And so the question becomes, is abortion a protected fundamental right through the implied right to privacy? Abortion was illegal in most states across the country by the early 1970s. And in some states like Texas, it was actually a felony to do an abortion unless it affected the health of the mother. But a woman by the name of Norma McCorvey, who went by the pseudonym Jane Roe in this case, had become pregnant for the third time. She did not want to have the child. She was already in financial dire straits. She was, in a pretty tight situation. And so she wanted to have an abortion. But the state of Texas denied her the ability to have that. Now, in the case of McCorvey, in the case of Roe, she ends up having the child. But before she has the child, she files the lawsuit in court. And it takes about 4 years for the case to make its way through the state courts of Texas to the U.S. Supreme Court. And so the U.S. Supreme Court had to decide, is the right to is an abortion a fundamental right that's part of right to privacy? And this is a tough situation because you're talking about, the idea of abortion as a medical procedure. And we've talked about the idea of having a right to privacy over what we do with our body behind closed doors. So there is that component of it. But there's also the added component that there is a compelling state interest to protect life. In this case, the life of an embryo, fetus, etc. So this is why this is a very challenging issue. In the end, the court will vote by a margin of 7-2 in favor of Roe and asserting that abortion is a fundamental right. However, there are some reasonable limitations that states are allowed to place on abortion rights via the Roe case. So what Roe tells us is that in the first trimester, states are not permitted to impose any laws restricting abortion. So in other words, in the first trimester, and so we're talking about the first 3 months of a pregnancy, states cannot deny a woman the right to have an abortion, period. In the second trimester, states still can't deny a woman the right to have an abortion unless the state can prove that denying a woman an abortion actually is going to be in the medical best interests of the mother. In other words, to help the mother physically in that case. However, the court makes a distinction between the first 2 trimesters and what it then considers to be true viability for a fetus, and that's in the last 3 months of the pregnancy. And the court then says the states do have a right, in the name of compelling interest to protect life, to ban abortions outright in the third trimester if they so desire. So the court has a very kind of a specific notion of when is viable life to be protected and when it's not considered viable life that is not required to be protected. And they kind of draw that line right there at about 24 weeks. So that's an important standard. Now, this is going to be a very controversial ruling. And it's, I would say it's the most controversial ruling of the last, 60 years easily. And the question then becomes, for those that are opposed to abortion, those folks that are considered pro-life on this issue, well, what about aspects of trying to place limits on abortion, though not outright outlawing abortion? For example, the Hyde Amendment is going to be proposed in Congress, which would ban federal funding for abortions. The federal government has a right to not subsidize abortions if it does not desire to. So, for example, no federal funds, pretty much the entire time since Roe v. Wade, federal government has not subsidized the cost of abortions. Now, the federal government has helped subsidize, things like Planned Parenthood, but not for abortion services. Another key case on the issue of abortion is Webster versus Reproductive Health Services in '89, which states that the state government does not have to use tax money to support abortion clinics. So it's not just a federal thing, it's also a state thing. Another important case, Planned Parenthood versus Casey in '92, which says that states that had established what were known as waiting periods. In other words, you might have a state that says that, hey, we're going to mandate that if you are a woman seeking an abortion, you would have to show up at the facility and wait for 24 hours or maybe even 48 hours to, think deeply about your decision before actually going through the procedure. And that was considered constitutional. That was not seen as an undue burden on a woman's right to have an abortion. We have seen states that have been allowed to mandate that the downsides of the downsides emotionally for women by an abortion can be mandated if a state so. Understand that there's this movement as the court has become more conservative in the 80s and 90s that abortion is still going to be a protected right, but you're going to see more and more allowances of state governments that really kind of chip away at that and really narrow what that right to abortion is, up to and including the case of Gonzalez versus Planned Parenthood from 2007, focusing in on the constitutionality of the Partial Birth Abortion Act. What the Partial Birth Abortion Act did was basically ban any abortion procedures that involved, and I know it's going to be a little graphic, but involved an abortion from which a fetus had already been partially delivered. The head has been delivered. Now, it can be, we're talking about an induction here, an induced delivery, but still the idea of banning that procedure. And the court upheld that federal ban, saying it was not an undue burden on abortion, that type of procedure was extremely rare, and so you could have that ban in place and still have the fundamental core of having an abortion be protected. So, Roe versus Wade, which, remember, folks, the case you got to know for the big AP test, is still something that's on the books as, asserting the idea that abortion is a fundamental right that fits under the right to privacy category. However, states have been allowed via the more conservative Supreme Court in the last generation or so to really kind of narrow what that is, to the point now where there's many states where there's only a handful of abortion clinics, or in the case of Mississippi, only one abortion clinic. And that leads us to a very interesting case that the court is looking at right now as we speak, and that's the case of Dobbs versus Jackson. And what this is taking a look at is the Mississippi law that was passed 3 years earlier that banned abortions starting at 15 weeks, that outright banned abortions at 15 weeks, which is in violation of the interpretation of Roe versus Wade, which dictates once again that states cannot outright outlaw abortion until after 24 weeks. So the court, which is, has its largest conservative majority in almost a century, is going to be reconsidering the idea of, is abortion still a fundamental right? Which means they could overturn Roe versus Wade outright and just say that abortion is not a protected right, which would then mean that states would be free to outlaw abortion outright because it's not considered a fundamental right. Or what the court could do is say, yes, it's still a fundamental right. Roe versus Wade is still going to be the interpretation of that moving forward. Nothing's changed. Or they can find a middle ground, which many, forecasters are kind of predicting might be what happens. And in other words, they might say that the right to an abortion is still a fundamental right, but they might move that time frame up in terms of, the viability of life from 24 weeks to, say, 15 weeks or 12 weeks. You may very well see the court say, hey, states can't ban an abortion outright in the first trimester, but could starting in the second trimester, which is different from what it is today, which is the third trimester. So that's going to be a very interesting result to see what happens moving forward. So, anyhow, that is substantive due process, right to privacy, and the impact of Roe versus Wade. We'll see you next time. Bye-bye.